Well, good afternoon, everyone. This is Stephanie Otts, the director of the National Sea Grant Law Center. I thank everyone so much for joining us today and the positive feedback that we've received on our information that we've been trying to get out on the CARES Act and all the other legal issues that are kind of coming up with respect to the COVID-19 pandemic. Just a bit of an overview of what we hope to touch on today. There's quite a bit that we wanted to share. We're planning on having a question and answer period at the end, but please use the chat box throughout the presentation to record your questions. Questions that we don't know the answers to off the top of our heads. We do work on a Q&A document that we post on our website following the webinar, so it's really helpful for us to know what parts aren't making sense, what's confusing, or what you might need more information about. So today we're going to primarily focus on Paycheck Protection Program loan forgiveness and associated questions that come up with that related to employee considerations as we're returning to work and tax consequences. Just for those who may not know us, just real quick, National Sea Grant Law Center is one of the 34 Sea Grant programs. We're based at the University of Mississippi School of Law, and we were established to provide non-advocacy, legal research, outreach, and education services to the Sea Grant network. All of the information that we're talking about today is available on the COVID-19 resources webpage that we have on our website. We try to update it daily. Information is changing really rapidly, so I encourage you to go to that website, and if you want more information or background about anything that we are talking about today. So just before we get into the meat of what we were talking about today, I wanted to go through to touch on just some general updates to be aware of. So as of today, the Small Business Administration's website still says that they are accepting Paycheck Protection Program applications. Yeah. So the SBA has been making some changes, including limiting submissions by the larger institutions to make it kind of in the spirit of the intention for smaller businesses. And so that might be making the funding last a little longer than the last round, but it's still expected to be gone pretty soon. They did extend the Paycheck Protection Program safe harbor time period until May 14th. So this came up in the context of, if you heard about the large restaurant chains like Potbelly and Ruth Chris getting paycheck protection loans, and there was kind of a public outcry about that. So the SBA has reminded applicants that they have to certify, or they had to certify in their application, that the funds were necessary to maintain ongoing operations. And if applicants give the money back by May 14th, then the agency will consider that certification to have been made in good faith. So it's just an opportunity that for someone who maybe took the loan out and it wasn't essential for their ongoing operations, or maybe they don't have the type of payroll expenses that they anticipated, they do have this window in which they could give the money back and not have any consequences for that. So that's something for businesses to consider. The SBA has also started accepting EIDL applications from eligible agricultural businesses with less than 500 employees. The portal is only open for agricultural businesses, and this was done in response to the fact that the traditional USDA funding in these types of situations is only available for natural disasters, and so farmers weren't able to tap into that. So in the most recent legislation Congress passed, they authorized agricultural businesses to apply for EIDL loans. Aquaculture is included in the definition of agricultural businesses. So this is an opportunity for aquaculture operators that might have been considering an idle loan but weren't able to submit an application because the portal was closed, to go back and apply for that funding. The other announcement that was recent that affects kind of Sea Grant constituents is USDA has announced plans to purchase $470 million of food, basically surplus food, for distribution. There's a lot of different commodities listed in that amount, but there is 70 million for fish. 30 million is for catfish, but they have 20 million for Alaskan pollock and 20 million for Atlantic pollock, haddock, and redfish. And so not available across the country for everyone of Sea Grant constituents, but if you do work with fishermen who are catching these species, this is a potential opportunity for them to sell to the USDA. Purchases are made through an RFP process, and it can only be from approved vendors. And so we've tweeted about this, and there's some information on our website about links to the USDA page for becoming an approved vendor. The RFP is not out yet for pollock, haddock, and redfish, so just stay tuned to their website for more. And with that, I'm going to turn it over to Catherine Janessi first to start talking about the Paycheck Protection Program.
So good afternoon, everyone. We, in the interest of time, weren't planning on going over background on the PPP program, but we wanted to remind you guys that we have a lot of information on our website, including a tip sheet for self-employed individuals, and Texas Sea Grant has actually translated a guide for their state based off that general tip sheet for their program in both Spanish and Vietnamese, if you think that would be helpful to your stakeholders. But I did want to spend just a minute to talk about some things to remember about the PPP. So PPP loans are meant to keep businesses running and maintain payroll. They're not supposed to be about spending money on other non-allowable expenses or expanding the business. Related to that, the loans cover an 8-week period, which is known as the covered loan period in the statute. So it's meant as a short infusion of cash to keep the business up and running during the pandemic, and is not supposed to be a long-term loan or solution for the business. PPP loans have very favorable terms for businesses, so no payments for 6 months. They have a low 1% interest rate. That interest rate will accrue during that 6-month deferment period, however, and the loans will become mature in 2 years. So all unforgiven portions of the loan must be repaid by this time period to the lender that the business got the loan from. A recipient does not have to spend the entire loan. And that's something that we've been seeing a lot as we've been doing our research, and we want to remind businesses of. And that's especially, so if repayment of any unforgivable part of the loan will be difficult for the business, even with that low interest rate within the 2-year period. And then finally, related to what Stephanie was talking about with the safe harbor and certification about the loans being necessary, the PPP loan application requires businesses to make multiple certifications. And the ones that are really important when we talk about loan forgiveness part is that the funds have to be used to retain workers, maintain payroll, make mortgages, interest payments, lease payments, and utility payments. And part of that, the business has to certify that I understand if the funds are knowingly used for unauthorized purposes, the federal government may hold me legally liable, such as for charges of fraud. And they also have to certify that they're going to provide documentation to the lender about how they spent the money to prove that they only used it for these authorized uses. We wanted to point that out just because in some of the articles we've been reading, they've been talking about using the loans for other purposes because they're kind of a low interest rate loan, but the businesses aren't supposed to do that. And if they do, not only could they be charged with fraud, but depending on the guidance that comes out as we see the loan forgiveness start to be implemented, they could actually maybe be barred from loan forgiveness completely. Okay, next slide, Steph. So as of this time, since we haven't really gotten into the loan forgiveness stage of the PPP, the SBA hasn't issued any guidance that solely focuses on loan forgiveness, but they have here or there been issuing guidance in their FAQ documents and the other interim rules, and the Act itself has a lot of information on this topic. So the SBA has said in guidance that the loan forgiveness can be up to the full principal amount of the loan and any accrued interest. To maximize forgiveness, the business has to spend at least 75% of the loan on payroll costs. That was not something that's in the CARES Act, but the SBA has instituted that in a rule due to the popularity of the program, and they feel like that best implements the purpose of the program, which is to keep employees being paid. So that means that no more than 25% of the forgivable amount of the loan can be spent on mortgages, interest, rent, and utilities that are related to the business and entered into before February 15th, 2020. The proceeds of any advance of up to $10,000 on an EIDL loan that the business received will be deducted from the loan forgiveness amount. And so that's just a purpose so that the business doesn't get twice the amount of free money, to try to keep the programs, again, stretching as far as possible for businesses. And what is important, and we're going to spend a lot of time on today, is this idea that forgiveness is based on the employer maintaining or quickly rehiring employees and maintaining salary levels. So forgiveness, first of all, is going to be reduced if the business has a declining number of full-time employees. Those employees don't have to be the same employees, but the numbers do have to be the same. So that's different than determining if the business was eligible for the PPP in the first place. So that takes into account all employees, including part-time employees. But when we think about employee retention for forgiveness purposes, it's only the full-time employees that get taken into account. And again, as we talked about before, independent contractors don't count as employees for purposes of PPP loan forgiveness. So money that's going to independent contractors won't count in that employee count. And then loan forgiveness isn't just based on that employee count. There's also provision in the CARES Act that says the forgiveness is also reduced if the wages for a single employee are reduced more than 25%. But that does not apply to any employee who's making a pro rata amount that's equal to $100,000 in a single pay period. So those higher compensated employees are actually excluded from that provision. Next slide, Steph. So we have a lot of information for self-employed individuals on our website. I mentioned that tip sheet that we had done. So a lot of this information can be found there. But the point I wanted to focus on that's a little different for self-employed individuals is that item that is owner compensation replacement. And so what that is it's limited to 8 weeks of 2019 net profit. And so when self-employed individuals are getting their PPP loan amounts, the SBA is now basing that off 2019 IRS Form 1040 Schedule C, line 31. And the agency has determined that when the business is paying out money to the owner itself, any forgivable amount in payroll to that owner is limited to 8 weeks of that net profit amount that's listed on that line in the tax form. Okay, next slide, Steph. So after that 8-week covered period for the loan, a business can submit an application with their lender for loan forgiveness. The lender must make a decision on that loan forgiveness application within 60 days. So the business will hopefully hear fairly soon about whether their loans will be forgiven. The statute is requiring certain documents. So CARES Act says that they should have documents verifying the full number of employees and their pay rates for the applicable time period, documents showing payments on mortgage interest, leases, and utilities, An authorized representative of the business has to make 2 certifications when it submits the application. The first is that the documents are true and correct. And that second one is that the amounts that are, asked for forgiveness are only being used for those allowable things, such as payroll, mortgage interest, rental, and utility payments. And then that statute itself mentions other documents determined by the SBA. So as the SBA, starts focusing its attention on the loan forgiveness aspects, we may see things added there that they want in addition to these other documents with the loan applications. Important to this is that the lender themselves don't have to verify the documentation that the business is submitting. They're not held liable if the business has lied. But in connection to the issues that Stephanie talked about at the opening with those bigger businesses getting the PPP loans they probably did not need, the SBA has decided that it's going to review all the PP loans that are greater than $2 million when they get them from the lender to look them over. And that provision also includes this phrase, in addition to other loans as appropriate. And at this time, we have no guidance from SBA about what that means. I don't know if we ever will. It may just be a catch-all phrase that they want to protect themselves if there's another application that they want to look at. But as a general rule, to the extent possible, the businesses, as they're spending this money, as they go through their 8-week period, they really do need to be maintaining documentations about how they're spending the money. And so that can include cancel checks, payment receipts, transcripts of accounts, and other documentation. And as I said, the SBA isn't really focused on this right now because they're still implementing getting the loans out, but the business has to be saving records as they spend the money. They certify that they would, and it's going to be required when they submit their application. Okay, next slide, Steph. Okay, so the relevant time periods for PPP loan forgiveness, there's 2 different ones. So the forgiveness of the PP loan is based on their spending over an 8-week period. So when does that 8-week period begin? And the answer to that is the date that lender makes the first disbursement of the PP loans to the borrower. The lender has to do this no later than 10 calendar days from the date that the loan was approved. And so that happens pretty quickly, and that clock for a business starts pretty quickly. And then the period that's important for them to make the employee reduction calculation is a little different. So the pre-pandemic time period used to determine the number of full-time equivalent employees is either January 1st, 2020 to February 29th, 2020, or February 15th, 2019 to June 30th, 2019. The business owner can choose either one of those time periods, whichever one they think is more advantageous to them. Now, the CARES Act says that seasonal employees have to use February 15th to June 30th, 2019. And what's interesting is last week, the SBA issued some new guidance for how to calculate the loan amount for seasonal employers. And when they issued that guidance, in order to be more fair, they thought, to businesses that maybe aren't up and running in the winter months, they said that the businesses, to calculate their loan amount, could use any consecutive 12-week period between May 1st, 2019 and September 15th, 2019 to determining their maximum loan amounts. And obviously those dates are very different than what the statute is saying that has to be used to count the number of employees. And so we are going to stay tuned to see how the SBA is going to reconcile those two sets of dates, because they are really different for seasonal employers. Okay, next slide, Steph. So we just wanted to run through a couple hypotheticals for you guys to see how this employee retention hypothetical and the 75% payroll cost rule play out. So let's say a small business receives a PP loan of $60,000. Prior to the pandemic, it had 10 full-time employees. And during its 8-week covered loan period, the business only retained or brought back 7 of those employees. So the first calculation we're going to look at is that 75% payroll cost rule. And so the total loan $60,000. The business spends $30,000 on payroll costs, $4,000 on rent, $2,000 on utilities, and so they've spent $36,000 of that $60,000 loan over the 8 weeks. That $30,000 of payroll equals 83% of the total qualifying expenses of $36,000. So as a result, there's no need to reduce the forgiveness request based on the 75% payroll cost rule. And just the flip side of that calculation is the non-payroll cost here only amount for 17%. If the non-payroll costs had exceeded 25%, we would have had a reduced what could be forgiven from them until it reached that less than 25% number. Okay, next slide. So even though the small business had a PPP loan of $60,000 and they spent only $36,000 on it, they met that 75% payroll cost rule. And so up to this point, that whole $36,000 is eligible for forgiveness. But we still have to go through this full-time equivalent employee rule. So from the last slide, as we said, during the 8-week covered loan period, the business only had 7 employees. The number of employees they had pre-pandemic were 10 full-time employees. And so that gives us a ratio of 7 out of 10 or 70% of what's going to be eligible for forgiveness. So we have to multiply that $36,000 times 70% to get the full-time equivalent employee rule implemented. And that gives us the final amount eligible for forgiveness. So that calculation means that the business, because they've reduced those full-time employees, will only get $25,200 forgiven based on this rule. The business then has to return the other $34,800 of the loan to their borrower. And so they have 2 years to do that, and it has to be done at that 1% interest rate. Okay. So to further complicate this hypothetical, let's say before the pandemic, the small business had those 10 employees. It laid off 3 of those employees on February 20th, 2020. The business's 8-week covered loan period ended on June 5th. It hires 3 employees back on June 15th, bringing its number of employees back up to 10. So does the business's PPP loan forgiveness amount is it still reduced? And the answer is no, based on an exception for businesses in the CARES Act. So the exception applies to businesses that had reduced their workforce from February 15th to April 26th, which is 30 days after passage of the CARES Act. That's the date given in the statute. And so under that provision, a business can avoid the forgiveness reduction for having a reduced workforce over the 8-week period, so long as they have the same number of employees by June 30th that they had on February 15th. And so that's, kind of a safe harbor for the business. Obviously, it may delay based on when their loan has been dispersed, when they can apply for forgiveness, but it is a provision that businesses can take advantage of if they're able to hire back their employees by that time period. All right, so finally, one last twist. So before the pandemic, the small business had 10 employees. It lays off 3 of those employees on February 20th, 2020. The business's 8-week covered loan period ended on June 2nd. It tried to rehire the 3 laid off employees on April 8th when it gets its PPP, but they refused. Their number of employees remain at 7 for the duration of their covered loan period. Is the business's loan forgiveness amount reduced based on this employee reduction rule? And the answer here is no. And so just this week, the SBA in its FAQ document for the PPP said they were having an interim rule forthcoming that would help businesses in this situation. So they say they're going to allow businesses who are trying to rehire to not be affected by this reduction rule. And the reason for that is the CARES Act gave the SBA the authority to make these small exceptions on the limits on loan forgiveness under the Act. And so what this rule is going to say, the SBA has indicated, is that it will exclude laid off employees whom the borrower offered to rehire from the CARES Act loan forgiveness reduction calculation. And so here we're talking about, before I mentioned that the number of employees don't have to be the same, but for this rule they do. So they have to go back to that employee and say, we're going to hire you back for the same salary, wages, and the same number of hours. And the business has to make a good faith written offer to rehire those particular employees. And the employer rejection has to be documented by the borrower. So if the borrower does all of these steps, they won't be hit by that employee reduction in their loan forgiveness. But kind of transitioning to what Tara's going to talk about next, employees and employers have to be aware that employees who are rejecting these offers of reemployment may affect their unemployment compensation. So with that, I'm going to turn it over to Tara, who's going to talk about those rehiring issues.
All right, thank you, Kathy. So yes, as businesses are opening up again following shutdowns, there may be questions about employees returning to work. Employees may wonder whether they are required to return to work if they still have concerns about coronavirus, or if they're eligible to still receive CARES Act unemployment benefits. And then employers want to know what type of protocols they are allowed to put in place as they reopen. So to start with, let's talk about whether employees are required to return to work. So for individuals to receive benefits under the CARES Act, they must meet certain eligibility requirements, such as being diagnosed with COVID-19 or caring for a family member or a member of their household who's been diagnosed. If this is still the case, employees can remain on unemployment until they are able to return to work. However, if the eligibility requirements are no longer met, the individual is no longer eligible for CARES Act unemployment benefits. Simply having a fear of catching the virus is not enough to meet the requirements. But with that being said, many state directives are making allowances for vulnerable individuals who may be at higher risk if they contract COVID-19. They may have outlined different return to work timelines for vulnerable individuals, such as those over the age of 65 or those with medical conditions. That will just vary by the state. It's worth noting that on Tuesday, the EEOC issued guidance for employers who are bringing back employees who are at a heightened risk. But by Wednesday, they had taken that guidance down. They said that what they posted had been misinterpreted. So we'll see what they come out with next. And then finally, OSHA is the federal agency that addresses safety in the workplace. They have issued guidance on preparing workplaces for COVID-19, and I'll talk about that in a minute. But the Occupational Safety and Health Act requires workplaces to be free from recognized hazards that are causing or are likely to cause death or serious physical harm. And so under the Act, employees may refuse to work if they believe they are in imminent danger. And the imminent danger standard is pretty high. So from what I've read, it would be unlikely that an employee could argue that they are in imminent danger from returning to work during the pandemic. So next slide, please. So what if an employee refuses to turn to work and there are no COVID-19 related reasons? Kathy touched on this a little bit, but if they refuse to return to work without these reasons, the state would likely find that the individual has voluntarily quit without a good work-related cause. And unemployment benefits are unavailable to employees who quit without a good work-related cause. If someone attempts to collect unemployment benefits, at that point, it would be considered fraud. They would be ineligible for any additional benefit payments. They would have to pay back the benefits, and they would be subject to criminal prosecution under federal law. And if that arises, or if anyone gets questions about that, just the thing to do would be to tell employers that they can report those employees to their state labor departments, who will take it from there. So let's next look at some employer concerns as a business reopens. What risk management steps should a business take, or what steps are they required to take to ensure employee health and safety? These protocols may be related to social distancing, sanitation, temperature checks, PPE, the promotion of healthy hygiene practices. Some of these are requirements under state or local laws. For example, some cities require those working at a retail establishment may be required to wear face masks or coverings. But then some federal agencies have put out guidance for preparing workplaces for reopening. And these address everything from social distancing guidelines to employee testing. So here are some of the websites that are worth checking out. It would be smart for businesses to develop plans or protocols in line with this guidance. Even if the guidelines aren't legally required at this point, plans could help protect employees. It would reassure employees who fear returning to work, and it could reduce employer liability. Excuse me. And then finally, employers should be flexible with employees. They can prioritize which workers return to work first based on government directives. They can work with individuals who have COVID-19 related concerns for returning to work. Okay, next slide, please. So finally, what are some of the testing and protocols that an employer can implement for employees? The Americans with Disabilities Act is the key component. The ADA protects applicants and employees from disability discrimination. So how is that relevant during a pandemic? So first, the ADA regulates employers' disability-related inquiries and medical examinations for all employees, including those who do not have ADA disabilities. So typically, the ADA prohibits employers from making medical examinations or inquiries unless the examination or the inquiries are job-related, consistent with business necessity, and there is objective evidence that either the employee's ability to perform essential job functions will be impaired by the condition, or the employee will pose a direct threat due to a medical condition. So EEOC guidance has said that COVID-19 meets the direct threat standard. So temperature screening questions by employers are allowed. And then next, the ADA prohibits employers from excluding individuals with disabilities from the workplace or for health and safety reasons unless they pose a direct threat. The EEOC has said that COVID-19 is a direct threat, so employees may be sent home if they exhibit signs or symptoms of COVID-19 or if they refuse to answer health-related questions. And then finally, the ADA requires reasonable accommodations for individuals with disabilities during a pandemic. So employers should keep that in mind when working with employees who are covered by the ADA. So with that, I'll turn it over to Zach.
Thank you, Tara. Hi, everyone. I'm here to talk about the tax consequences of PPP loans. Just as a general background, loans are not normally considered income for purposes of federal income tax. However, forgiveness of loans is, or forgiveness of loans are. Separately, businesses are usually allowed to claim a deduction for ordinary and necessary business expenses. So this may be wages, salary, rent, utilities, etc. With all of that in mind, Section 265 of the Internal Revenue Code prohibits claiming a deduction for expenses that are allocable to tax-exempt income. This is to prevent double dipping. There would be a double tax benefit if there were income that was tax-exempt from which the individual here, the recipient of a PPP loan, could then claim a deduction from their income tax or from their income. So with all of that in the background, Section 1106I of the CARES Act identifies income. I'm sorry, I got ahead of myself. Section 1106I notes that any debt that is forgiven, any of the PPP loan that is forgiven, is excluded from a recipient's gross income. So this is a little different. Normally, loan forgiveness is included in gross income. Under the CARES Act, these PPP loans, if forgiven, are not. But what does that mean in light of some of the other code provisions that we've talked about? Well, it means that any expenses that are paid out of PPP loans that are then forgiven cannot be claimed by the recipient of a PPP loan on their federal taxes. So if they're using this money as they're supposed to be for paying wages, for rent, for utilities, and then that loan is forgiven, a recipient of a PPP loan then cannot claim those expenses paid out of the PPP loan like they normally would for other ordinary and necessary business expenses. There is a little more background here. If you're interested in learning more and what some of the other implications might be, we have a link at the bottom here for the IRS guidance that you might find helpful. Next slide, please. Thank you very much, Stephanie. All right, so this is the first hypothetical to go over this concept. We're going to work with Company A, who has successfully obtained a PPP loan of $100,000. Company A spends $80,000 of that $100,000 on salaries and wages, and the remaining $20,000 on rent and utilities. So how much of that PPP loan must Company A include in its gross income on Company A's tax returns? Well, because all of the expenses are forgivable, it doesn't have to claim any. In fact, it should not claim any. This is tax-exempt income. But how much of the payments made for salaries and utilities, mortgage, etc., might Company A claim as a deductible? Here, it's still zero because all those expenses were paid through money that was ultimately forgiven in the loan. Tax exempt, they can't claim it as deductible. Next slide, please. Thank you. Here's a second hypothetical, a little different. Now we're working with Company B, who has also obtained a PPP loan of $100,000. Company B spends $75,000 on salaries and wages, $15,000 on utilities, paying off the interest on its mortgage, and $10,000 on paying back interest on a pre-existing debt obligation. So just to break this down a little more, we haven't gone over this a ton, but there is a slight distinction between forgivable expenses and allowable expenses. The $75,000 spent on salaries and wages and the $15,000 spent on utilities and paying off the interest on Company B's mortgage are all forgivable. However, that last $10,000 spent on paying back the interest on a pre-existing debt obligation is allowable with PPP loan money. However, as of now, at least, it is not considered forgivable. So with this in mind, how much of the PPP loan must Company B include in its gross income on its federal tax return? The answer is zero. The loans are not taxable income, and the CARES Act excludes the amount forgiven. But the second question is then, how much of the payments made with the PPP loan money may Company B claim as deductions? Well, now because that last segment spent on the pre-existing debt obligation is not forgivable, but it is still considered a deductible expense, at least presumably for this hypothetical, the answer is $10,000. It can claim expenses paid with a portion of a PPP loan that is not forgiven. However, because the loan is not forgiven, it will have to pay that money back to the federal government within 2 years, according to the schedule that's laid out by the statute. And just two brief notes before wrapping up. First, there is ongoing debate as to whether, upon forgiveness of a PPP loan, your company will, for state tax purposes, have a discharge of indebtedness income. meaning that it's unclear right now as to whether if your PPP loan is forgiven, this might still count as a forgiven loan and thus taxable income for state tax purposes. The second thing, and this is very true, Kathy mentioned this with her information earlier, you should be working very closely with your lender and your accountant or your lawyer, if you have one, to ensure proper documentation. Proper documentation is going to be very important. And with tax consequences, as with the other facets of the CARES Act and the PPP, you should check the SBA site frequently for new information as it comes out. Thank you.
Thanks, everyone, Zach, Kathy, and Tara, for your information. And I know that's probably overwhelming to a lot listening on the phone. Stuff is getting, we thought it was complicated before. It's getting more complicated as additional guidance comes out. And so we're trying to outline the best we can all of these interconnected pieces. But we welcome questions in the chat box. I'll give folks a minute to collect their thoughts and see if they have questions. I don't see any coming in yet, but we do appreciate everyone joining us today. Yeah, so someone asked if the webinar is recorded. Yes, we record the webinars and we post them. Usually we get them up before the end of the day of the webinar. So like check back by the end of the day on our website, and the recording and the slides should already be posted. Right. Well, I don't see any questions. So thanks everyone for joining us. I know that there's a lot of obligations on our times and everyone is zoomed out a lot. So we do appreciate you joining us, and stay tuned. Yeah, the best place to stay up to date is on our social media page. So please follow us on Twitter and Facebook, and check back to our website frequently for more information, and reach out directly if you have specific questions. Oh, someone asked about any word about the $300 million for fisheries. So yes, so there's been a lot of attention. The Department of Commerce still has not put out any guidance or information about that plan. So there's some information floating around that it is going to go to state agencies for distribution, but yes, stay tuned for more information about that. Oh, nope, Doug Lipton just said the 300 million was released an hour ago. So good news. Thanks, Doug. Someone asked, do the same ADA policies apply for university students as employees? Tara, do you know, the American for Disabilities Act does apply to students. There might be different guidance for universities as they bring students back, but it would be similar considerations, I think, for students with disability.
Yeah, I would think that students would be included in the definition of employee, but I don't know for sure.
Good. Well, great, everyone. Thanks so much for tuning in, and let us know if you have any questions, and we appreciate your participation. Thanks.